I want to continue reading some of this report from the Integrity Commission. The executive summary says during the financial year 2023-2024, the Commission continued to make progress in the undertaking of its mandate guided by its established strategy priorities. It was a very extraordinary year for the Commission, one in which the entity achieved an overall creditable performance in its statutory and operational activities. And these are the details they say, though some of them were not without challenges. They say, pursuant to Section 5, subsection 4 of the Act, the Commission is headed by commissioners who are responsible for the governance and oversight of the organization. In the performance of its functions under 17 and 25, the Commission during the reporting period convened 14 meetings of commissioners, 16 audit finance committee meetings, 11 corruption prevention meetings, 7 resource and corporate governance meetings, 17 information and complaints meetings, 14 investigation and corruption prosecution committee meetings. And then they go on with more. The anti-corruption activities now. The Commission recorded compliance rate regarding the submission of statutory declarations of 70% for public officials and 88% for parliamentarians. For the 2023 statutory declaration intake. God, I don't understand. Maybe it is how they've put the objects of the law, or that opening paragraph that they have at the top, where they say something about parliamentarians and other public officials. Maybe that is why the Commission insists on segregating the thing public officials and parliamentarians. And this is the thing that has created all of the problems, you know. Yeah? This is what started everything. So we get, even for compliance, we get a different breakout for public officials, apart and separate for parliamentarians. So we hear 70% of public officials submitted statutory declaration and 88% of parliamentarians complied. During the reporting period, the Commission's compliance rate showed increases for all statutory declaration periods, recording the highest compliance rate. Of 84% for the 2021 statutory declaration period. I don't even know what this means. Because if you told us about 88% for parliamentarians, how could you say the highest compliance rate was in 2021 of 84%? Is this now the overall average for the entire group of public servants when you include parliamentarians? Perhaps. The Commission also examined a total of 1,268 statutory declarations. So this is the problem here. They don't give us the total numbers yet of what was submitted. You know, they gave us the percentages of compliance, the percentages for the rate of compliance. But in the next sentence, they tell us they examined a total of 1,268 statutory declarations and certified 988 of those during the reporting period. Both examination and certification reflected a 125% increase over the period, and 7 declarants were referred for investigation. There are too many things operating in this thing, in this one paragraph alone. When you're giving percentages, you must also give us the actual number you're dealing with. So we have percentages in the first couple sentences, and then they go on to give us numbers, and then they give us percentage increase. I'm sure later down in the document, based on some of the reporting I've seen, They've given you both the actual number and then deal with percentages. But this particular paragraph on statutory declarations is giving you percentages one time, then numbers that they examined, then numbers that they certified, and then they tell us the percentage increase in examination and certification over the period, and the number of declarants referred for investigation. And I told you we have to figure out what this word means, referred for investigation. Yeah? I suspect based on what is in the law, it may mean a complaint comes into the Director of Information and Complaints. It's sifted and it passes the sniff test. And it's then referred to the Director of Investigation for an investigation into whether there is more that can lead to a possible charge of one of the variants or the creatures under this broad umbrella of corruption. Then they tell us 172 complaints and information were received or identified for assessment by the Commission during the reporting period. What does it mean to be identified for assessment by the Commission? 19 of the complaints / information assessed were referred to the Director of Investigation. So they got 172, but out of that it appears 19 were referred or sent to the Director of Investigation. 85 were closed. So the Information and Complaints Director, perhaps having assessed it, formed the view that 85% of them couldn't go any further, and 7 of them they're keeping in review. The Commission prioritized the more serious complaints / information received during the reporting period. And I've heard some people say, or the view has been posited, that it appears that whenever a call is made to the Integrity Commission or information provided, which may be, as I said, based in sus or malice or any sort of unfounded allegation, then it is somehow propped up to top shelf and becomes the source of anarchy. Come here for me, please. And becomes the source of something in the report. However, it appears from what we're seeing here that there is more than that. In that 172 complaints and information were received, and out of those, only 19 referred to the Director of Investigation, and 7 were kept in view. Okay? So I don't think it's pure sus under which they're operating. The mere fact that they record the number of complaints received, but the number directed to investigation, which is a lower number than the complaints received, it says a lot. Am I to join? Let's join I've just had a call from the speaker. We've been trying to reach her, and she's just called back. We're going to connect with her quickly for 2 minutes before we end the program. 876, well, let's see if we can get onto that. The Commission, as designated authority, continued to focus on operationalization of protected disclosures. The Protected Disclosures Act of 2011. 143 of the 169 protected disclosures procedural guidelines received from public bodies were approved by the end of the reporting period, 31st March 2024. All right. So the accounting period runs like the fiscal year. and they table their report by the end of June of the year. That's about 3 months after the end of the reporting period. There's a lot. I was just on page 12 for the executive summary, and at the appropriate time, we'll.
A well-known journalist and talk show host. Well-known journalist and talk show host Emily Crooks is giving us a breakdown on the Integrity Commission report. And for the benefit of those who are saying to themselves that this makes no sense, I would advise you not to say that. Because believe you me, based on what is going on now, we the Jamaican people must get an understanding of the Integrity Commission report. You all can hear me? Let me know if you all can hear me. We all must understand and come together. Let me know if you all can hear me, please, because I didn't plan to come on air this morning to speak about this because I have other things doing, but I see it fit to come on air and let everybody know what is going on. Let me see if I can hear myself as I go on this thing here. We're going to play another audio clipping from Emily Crooks. And it's very important that we all get a drift of what the good lady is saying. Thank you very much. Of what the good lady is saying. Because it is something important for all of us to listen to what is being said. Because many of us don't understand the nitty-gritty of the Integrity Commission report or the nitty-gritty of the Integrity Commission Act. And that is why yesterday, myself and my good friend Wilfred Rattigan was explaining it to you all. I want to go back to another clipping of Miss Emily Crooks' views and also what she was saying. It's something important for all of us. Hold on there for me. I think I did something wrong here. Oh, Lord. Did I? No, I didn't. No, I didn't. Hold on for me, please. Let me go back into this here. Yes. It's very important for all of us to listen firsthand in what other people are saying. Especially an attorney at law and well-known talk show host, Emily Crooks Shields. And I get I'm getting what I should say, I'm learning a lot from what she's saying. And I want you all to listen to this and take it from somebody who knows or who is going through the Integrity Commission report and the act. Wilfred Rattigan will be going through that come Saturday. We all can go over to his page and listen to him also. I think I'll be joining him on that forum. But for the time being, let us listen to what Miss Emily Crooks has to say. And she was speaking on this part here now about the calling for the ICG to commence an act investigation on fear of Mr. Seymour Panton, Justice Seymour Panton. And I want you all to listen to this, please. Here we go. I'm going to stop the talking that you all listen to it.
Thank you, listeners. We're back with you on the hotline. We do have On the Pulse with Public Health coming up in a moment. But I want you to have an appreciation of what is contained in this Integrity Commission report for 2023-2024, because the reporting year, the Commission needs to, every year it has to put in a report before the 30th of June. And I want to read this for you. I want to read firstly the chairman's remarks and start with part of the executive summary, because I think part of the chairman's remarks, parts have been interpreted to mean that any call or any passing of information to the Integrity Commission, irrespective of the origin, sus, malice, or otherwise, then that information forms part of report, such as report of investigation into an illicit 6 or illicit 8, whatever the number is. But when one reads the executive summary, and indeed when one reads the law, then we'll see that it's not so much every call that comes in that becomes an investigation, but there's a sifting process that takes place by the Director of Information and Complaints, who does sort of a triage and reports up to the Director of Investigation if he's satisfied that there's more that an investigation can uncover about information that is given. So the chairman, the Honorable Mr. Justice Panton, retired, President of the Court of Appeal, retired. He says, during the past year, the Integrity Commission continued to do what it's established to do, commend the staff and so forth. In terms of ethics, Commission was established to promote and enhance standards of ethical conduct for parliamentarians, public officials, and others in keeping with this mandate. I couldn't understand what this is about. The Commission wrote to the Honorable Speaker in March of this year in respect of a statement made by a parliamentarian shortly after the municipal elections held in February. To date, there has not been acknowledgement of the Commission's letter. I should like to think this has been an oversight on the part of the Speaker, as I refuse to think that she deliberately ignore such an important communication. The Commission is watching to see what action will be taken. I would love to know what comment is it that was made and which the chairman wrote to the Speaker about. He speaks about staff. From time to time, reference is made to the sum of money voted by Parliament for the operations of the Commission. It needs to be stated, notwithstanding the budgeted amount, the fact is that the Commission's staffing is not at the desired level. This understaffing is due in part to restrictions imposed by Finance Ministry as regards the level at which the Commission can place an employee within the approved salary scales. Consequently, the Commission is at a disadvantage in the recruitment market. I need to find out from the Finance Ministry about this scale that restricts the employment of individuals to the Integrity Commission. But more importantly, I think the Integrity Commission has to get on quickly with the electronic system for verifying statutory declaration and assisting it, and it may not need as many people as it believes it needs, because technology will actually do the work faster without, the need for people to be sort of using a microscope to comb through some form submitted by handwriting. But I need to find out from the Ministry of Finance what that is about. So the legislation specifies that certain persons are to make annual declarations of their incomes, assets, liability, and it provides penalties for those who do not comply. Certain statutory posts called directors are created and powers granted to the holders thereof to make inquiries, to make queries, conduct investigations, and prosecute where breaches occur. Acts of corruption, as defined by the Integrity Commission Act, also fall under the purview of the Commission. The Commission has an executive director responsible for day-to-day management of affairs of the Commission, other than those assigned to a director under the Act. The commissioners are to see the proper execution by relevant officers of the various tasks prescribed in the legislation. The law restricts the Commission from making any report or public statement, in relation to the initiation or conduct of an investigation by the Director of Investigation prior to tabling a report in Parliament, insofar as statutory declarations, government contracts, and prescribed licenses are concerned. The law states that every person having an official duty under the Act shall regard such matters as secret and confidential. Penalties of fines and imprisonment are prescribed for any breach. Given the state of the legislation, this is what media have been quoting, it is irritatingly unfair and unreasonable for persons, some of whom know better, to be questioning or requesting the Commission to speak on matters relating to statutory declarations or investigations. In my view, Jamaicans are quite low on the ladder of compliance as regards the various laws passed by Parliament. The Commission ought not to be, and indeed will not be, in such company. We await the amendments that we have suggested. Then the Commissioner, the chairman, says, of course, there's nothing preventing declarants or persons under investigation from speaking on the situation as it relates to them. Let me just say respectfully. In fact, I never preface a sentence with respectfully. And in fact, I'm going to take back never, because one must not engage in the practice of being so absolute. So I retract never, and I retract respectfully, because everything I say respectfully. If it comes across any other way, I beg you not to interpret it as such. I do not agree that there's nothing in the law that prevents persons under investigation from speaking. The statutory declaration, as I said, is not an investigation. An investigation is a different tier of action, specifically in the remit of the Director of Investigation. And from my interpretation of Section 53(3) of the Integrity Commission Act, in particular, but the whole thrust of Section 53, which deals with the secrecy of the investigation, I do not believe that those under investigation, if they know that they are statutorily allowed to say, if there's anyone who has, you see, the law, this particular law has not criminalized a person who is being investigated speaking out. And there's no need to do that. It's a stupid thing to do that. Because the reason for the protection under secrecy is to protect that individual. If the individual wants to rid himself of the protection to his own folly, then so be it. But it is my interpretation, even if another interpretation is possible, then I am of the view that if you're under investigation and if you know, having been told by the Commission, it is not something that the law countenances that you are to disclose. In fact, you may engage an attorney if you're told, and when you engage an attorney, privilege attaches to the communication between you and the attorney. And the attorney can't come disclose that information unless you authorize him to do so, which would go back to the first point. Yeah, but I respect the right of, anyone to have a different view. And what the former president of the Court of Appeal has said here is that, in his view, there's nothing in the law that stops somebody under investigation from speaking. I agree that in relation to the statutory declaration, nothing stops that individual from speaking. But having had a conversation here with Jeanette Calder concerning calls by the Prime Minister. The reason I said the Prime Minister cannot speak is on the basis of the discussion I had with her that they having delayed because of inability to supply or whatever the reason, to supply the information to the Director of Information and Complaints to satisfy him on the bona fides of the information relating to statutory declaration. We were on the trajectory that 2-3 years, really too long for that sort of certification process to be going on. And the next step would be for the commission to, a recommendation to be made to ratchet the matter perhaps up to the Director of Investigation, in which case a special report could be made in Parliament. And on the basis of that special report, the Integrity Commission could say little. And if that is the case, then the Prime Minister, in law, could not speak. Yeah, so that was the context of the conversation I had some weeks or months ago with Jeanette Calder. But the chairman of the commission went on in his report to speak on the Prime Minister's statutory declarations, and I find the language used here to be quite interesting. He says, much has been written and said in respect of the certification of the PM statutory declarations. The Act makes special provisions for the statutory declarations of the PM and opposition leader. Hear what he says. The Director of Information and Complaints is required to examine their declarations. And where he is satisfied that it is duly completed, he is to inform the Commission. Upon being so informed, the Commission is to publish a summary of the statutory declaration in a form that is set out in the 3rd schedule of the Act. And I pause to tell you, this is examining. It is not an investigation, and the language of the law is explicit. And the chairman repeats the language accurately. There's one, I believe, one section of the law speaks of inquiries, but the law makes a distinction between inquiries and investigation. It must be remembered, says the chairman, that to satisfy himself of the due completion of a statutory declaration, the Director of Information and Complaints, quote, shall make such inquiries as he considers necessary. The inquiries are aimed at determining accuracy. Given the restrictions imposed by the Act as regards statutory declarations generally, and then he says, and matters related thereto, I may only say that the processes of the Commission are nearing completion in respect of the Prime Minister's declarations. And this particular language has had me wondering, yeah? Given the restrictions imposed by the Act as regards statutory declarations generally, well, and matters related thereto, I may only say that the processes of the Commission are nearing completion in respect of the Prime Minister's declarations. We'll see. Then in terms of the obstacles now, the Director of Information and Complaints is empowered to make such inquiries as he considers necessary in order to certify or determine the accuracy of a statutory declaration. The Director of Investigation has a duty to investigate all allegation that involves or may involve an act of corruption or any allegation relating to non-compliance with the provisions of the Act. And guys, you need to know the difference between these two directors, their functions. Yeah? Inquiries, examinations, queries of statutory declarations, these are my words now, those are not investigations. Yeah? The person who does the investigation is the Director of Investigation, and that person has a duty, as quoted by the chairman directly from the Act, to investigate any allegation that involves or may involve an act of corruption or any allegation relating to non-compliance with the provisions of the Act. It should not be assumed that there is smooth going in the execution of these roles by the two directors mentioned. They face similar or significant resistance from time to time by some individuals as well as some institutions. Those who followed the proceedings in the court would have noted that the Commission had to go to the Supreme Court to get an order for Barita Investments to comply with a request for information. Let me pause here because I also hear the civil society groups latching on to this and, making call for there to be whatever sort of compliance and so forth. Listen, particularly because I practice in the civil courts, the provision surrounding even request for information, it's a provision that has had a whole body of case law around it. Yeah? Because certainly within the context of a claim, what one is asking for, one has to make out the direct relevance of the matter to whatever one is investigating. So I wouldn't read too much into an entity such as a financial entity initially resisting or desiring the court to make an order setting out in clear terms what exactly they're to comply with and what is to be given. Yeah, because sometimes it is the best way. You as the bank will have to try and safeguard yourself as well from any liability that one can accuse you of as the customer of the bank. So the fact that there's a provision in the Integrity Commission Act for banks to share this information doesn't mean that the banks shouldn't satisfy themselves on how it is that the information is to be shared, exactly what documents are to be disclosed, and a court can set out with some exactitude what is to be disclosed. And sometimes it's really probably to protect the institution from liability while the institution resists a request and seeks to defend the matter in court so the court can give an order. Yeah? So Barita is singled out for failing to comply. The chairman says Barita is not the only institution that has hesitated to comply with the Commission's legitimate requests. There is one other institution that has not been cooperative with as the Commission would have liked. I wish to use this medium to urge financial institutions to respond positively and truthfully when the Commission comes calling. It is unwise for them to endanger their licensees or their relationships with international or external bodies. As indicated in an earlier message, it cannot be business as usual. Delays in investigating matters are also caused by lawyers for declarants who seek multiple adjournments when the Director of Investigation has had occasion to summon a declarant for a judicial hearing. And this language is interesting. And again, you see how all the processes have to be intertwined, because whereas the Commission can request information, each and every person who is summoned to come before the Commission has a right to take an attorney. And if the attorney is not satisfied with whatever, to seek an adjournment to put himself or herself in a better position to have the person answer.
Wow. Very interesting analysis by Emily Crooks pertaining to the Integrity Commission. And since some people believe that she's misleading in what she's reading of what Justice Seymour Panton just said, the chairman of the court, the chairman of the Integrity Commission, former president of the Court of Appeal. If you believe that she's misleading, then I think you should open a YouTube channel and explain to the Jamaican people in what way is this lady misleading something that is being written by Justice Seymour Panton, the chairman of the Integrity Commission. And you know, we all must take in consideration, or we all must take, let I rephrase this. We all must listen keenly to what people who have legal mind pertaining to the Integrity Commission and legal mind pertaining to what is being reported by the Integrity Commission. Because if you listen to what Miss Emily Cook said, that she take in consideration some of the languages that is being used in the report, or in the thing that the chairman of the Integrity Commission wrote. And that is why, you see me, I love to listen before I speak. And I don't put politics in front of anything that I'm talking about. I listen and I analyze and I ask questions. And I think that's what we all need to do. It's been a pleasure listening to her. We have more to come, but we don't have any time today to do it. Maybe later on this evening, I decided to just make you all listen to this. It is very important that we listen, because there are some clause and something in the Integrity Commission Act that you and I don't know about. And that is why yesterday I bring on Wilfred Rattigan on my program to explain some things to us. Same way, we didn't know that the Constitution, the head of the Constitution stated the order in council, Jamaica order in council, that the Petty Council order Her Majesty then. So the Constitution of Jamaica is an order in council. You know, we all need to really listen and go back and do our research, as what we always said on this program. Don't take what I say for a grain of salt. Go and investigate it yourself. And so we intend to continue to educate and empower the people on this platform here. And I want to tell you thanks for coming on. Thank you very much for coming on. You know, and we have some more to listen to the views and what she's reading. And of course, we are going to get people on this platform here to speak to us some more about the Integrity Commission. It's a possibility that I may get a team of people to come on this evening. You know, yesterday we had a robust discussion with Senator Gabriela Morris, who is the youngest senator. She's running for Northwest St. Anne. Wish her all the best in that. But as I said before, we all need to sit back, listen, pick sense out of nonsense, what we don't understand. We ask questions, but if we believe that what the person is saying is not true, we go and Google certain things and we get the answers. Get the answers. I want to tell you all thanks for coming on to the program. It is now 12:58. It is 11:58 in the land of wood and water. I want to say thank you all for coming on. We're still working on some stuff to get into St. Elizabeth. We're still working on some stuff to get into St. Elizabeth. want to say thank you all for coming on. Thank you all for being a part of the Mek Wi Talk program. Until you hear my voice again, I am Jeffrey Tavares saying thank you all. Remember to like, share, and subscribe. And remember to continue praying for a great nation, Jamaica land we love. Have a great afternoon, everyone.
When the game gets rough and this life just seems so tough, Mek Wi Talk, my people, Mek Wi Talk. When this town becomes an ugly place, don't let it erase the smile from your face. Mek Wi Talk, people, Mek Wi Talk. Conversation is the key, a guiding light for you and me. Spark a talk and you will see. Conflict solver A to Z. World leaders master the art of self-defense just by talk. So people, Mek Wi Talk. Hey, we're living in a world that on ourselves we must depend. Mek Wi Talk.